In the labor sphere, with we're talking National Labor Relations Act, National Labor Relations Board, what we have seen, really, if I'm being frank, for like the past 10 to 12 years, is a swinging of the pendulum back and forth between administrations. My practice, especially in the labor field, is very negotiation driven. It's very driven to negotiating agreements, negotiating decisions, putting decisions in front of arbitrators. The term bargaining table is not just a term, it literally is a bargaining. This is bar none, far and away, cannot overstate it, the field where employers most likely get tripped up.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, a podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a partner and litigator who serves as a trusted resource for employers that are navigating the challenges of the modern workforce. He guides clients through high-stakes employment litigation, intricate union negotiations, and ever-changing compliance laws. He was recognized as a rising star and recently named a Tomorrow's Leader by the organization International Employment Lawyer. It's my pleasure to welcome Steve Nevolis to the podcast. Welcome, Steve, and thank you for being here.
Good morning, and thank you for having me. I really appreciate it.
Thank you. The pleasure is all mine, Steve. As you know, before we get started, I always ask each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
A fun fact.
Please.
Okay. So in this age of everyone always Googling each other, I always find it funny that for a period of time, when you Googled my name, there would come up an article about me in the Milburn, New Jersey Times or whatever it was, that my job was a zucchini specialist. And we laugh about this because my wife, when we first met many years ago, when she Googled me, that was what came up. And so she jokes about it to this day. And the story behind that is, I grew up in Northern Jersey, and the year or so before, it was the summer before law school. It was 2009, and it was very hard to get a job for someone in 2009 who was just going back to school, a summer, like something for the summer, that was going back to school in 3 months. So there was a farm in my hometown that did farmers markets, and I knew the owner. And he said, well, why don't you come do some of the farmers markets? And we went to towns all around northern New Jersey, like Milburn and Morris Plains and Jersey City. And if you know anything about Milburn, Milburn is a very nice town with a fantastic deli. And it's got a little train station downtown where they had the farmers markets. And there was a local news reporter who was doing an article on the farmers markets. And she comes around and takes pictures of our markets and everything. And she was going to write an article. And she said, I'm going to use this picture and I need a caption. She goes, what is your job title? I'm like, I don't know. I don't have a job title. Just do whatever you think is appropriate. And she goes, okay, I get that. And then she wrote the article. I don't think I ever really saw it. And then like a year or so later, my wife Googles me and she goes, do you know there's an article about you saying you're a zucchini specialist? And so she sends it to me and I look at it and it's a picture of me over a rack of produce, like rearranging squash and zucchini. And it had my name. It says Steve Nevolis, zucchini specialist at Ort Farms. And I just think now at this point in my life, it's been pushed down to the bottom of the Google search engine because my name appears in a lot of court cases and articles that I've written. But there was a point at the beginning of my career where that was one of the first things that came up.
That is hilarious. That is one of the most fun facts I've actually heard. It's funny. I thought the story was going to go in a different direction where maybe there's somebody with a different name who actually was, a specialist, but it really was you. I think that makes it even more fun than that. That's outstanding.
And what's funny is I think like several years later we started a garden and my wife's like, well, you're the zucchini specialist, so you're the one who has to be the best, but I don't have it.
That's a great way to start. Steve, one of the things that I consider for all of my guests is that if you make the time to come onto this podcast, you're a superhero, and every superhero has an origin story. What is yours?
Sure. So I mean, I've wanted to be a lawyer since as long as I can remember. I read The Rainmaker by John Grisham when I was like 12, and I also watched the movie, which if you've ever seen the movie with Matt Damon, it's one of Matt Damon's first roles. It is really good. So I'd always thought that that's what I wanted to be. So I went to college, I went to law school. When I was coming out of law school, I graduated in 2012, and it really wasn't the best time to be graduating law school. And I really didn't know what area I wanted to go into. And my father at the time was a teamster for a company, and he's like, "You should really look into being a labor lawyer." And I was like, "I'm not really sure that's what I want to do." And at the end of the day, when I was coming out of a clerkship, I had a couple of interviews with firms, and one of them was to be a labor lawyer. And I had interviewed with the firm, and I really enjoyed the folks that I interviewed with. And I was like, you know what, maybe this is the direction I should go in. The clerk the year before me had also gone into that field and had recommended it. And so I just kind of fell into that path and have been doing it really at this point close to 15 years.
Fascinating. One of the things one of the things I noticed when I was looking, researching your path and your bio and things like that is that you've obviously worked at several top firms, including right now. But in the middle, you also had a significant pivot where you were in-house at a major medical center, and then you returned to a firm as a partner. Can you maybe talk us through the transitions that you made and why you made them?
Sure. So really, my transitions at the beginning of my career, I started my career in New Jersey and worked at a couple of firms, really just based on, worked at my first firm for a little over a year and then was recruited to go to my second firm. And then after my second firm, I had made the move to Nixon Peabody in New York. And the real reason why I did that was at that time, my parents lived in Northern Jersey and they were moving to Florida. And my wife's family lives on Long Island. So we said, maybe we should have a look at moving to New York. We decided to make the move to New York, where I had met some folks at Nixon Peabody and got a job really, and that's really where I got headlong into being an employment litigator, because before that I was really more of a labor lawyer doing kind of a lot of labor negotiations, arbitrations, things like that. And then I was at Nixon Peabody for a little while, and my law school roommate actually was working at Kelly Dry & Warren in the labor employment department. And he called me and said, "Listen, we're looking for someone who is, about our experience, someone who graduated the same year that we did. Why don't you come and meet the folks that we work with?" And I met them and hit it off and ended up going to Kelly Dry and working there for a few years. About 3 years in, I was working, and we represented the client that I went in-house with, and I worked with them. They were a client of ours, and I won some cases for them. Around the time I was having my first kid, the client, the general counsel at the time, she approached me and said, would you want to consider coming in-house? I know you're having your first kid. Maybe you want to get away from the billable hours. I think it'd be a good experience for you. So I took the leap and I went in-house. And I went in-house to one of the largest medical centers in New York in November of 2019. So about 6 months before COVID. So then COVID hit, and I was in that job for about 2 years. And then after about 2 years of doing that, while I really enjoyed my time in-house as an in-house lawyer, I think it provides, especially labor and employment attorneys, it provides you with a unique perspective on how the practice is and how it runs, the advice you're giving and all of that. I felt that while I enjoyed my time there, my world was really to be in a firm. And that was where I thrive. That's what I enjoy doing. I enjoy meeting a lot of clients, working through their issues. So then I went back to Kelly Dry for a little while, and then now I'm at my current firm, where I'm really focusing on labor unions, unionization efforts, and helping clients on the day-to-day kind of things as they go through these really kind of crazy employment law times that we're seeing in the United States.
That's fascinating. I have a couple of different threads that I want to pull out there. So one of the things you mentioned was that there was a conversation where you were being brought in as an employment litigator, whereas your prior work prior to that point was maybe on the labor negotiation side. For those of us maybe less familiar with the work that you do, can you maybe draw out a distinction between being an employment litigator and being more on the labor side?
Sure. So When we talk about labor and employment, that's kind of a whole universe of a practice area, right? So traditionally, the labor and employment practice it was a labor focus. And that goes down to the fact that like 100 years ago, the government passed what's called the National Labor Relations Act, which allowed employees to unionize. And it allowed employees to bring cases to what's called the National Labor Relations Board, an agency that's been in the news a lot recently. So really for the first iteration of labor and employment law really was dealing with labor relations. You dealt with unions and arbitrations and grievances and collective bargaining and union campaigns and things of that nature. So then it wasn't till around the 60s and 70s when a lot of the anti-discrimination laws started being passed, and Equal Pay Act laws, wage and hour laws, things like that, that we then developed kind of the field what's now known as employment law. So employment law is really not labor issues, it's not unionized issues. It's dealing with, for example, Title VII, the anti-discrimination laws, or the Age Discrimination in Employment Act, or the FLSA, the Fair Labor Standards Act, which has to do with wage and hour laws, has to do with non-compete and non-solicit agreements, things like that, things that affect employers and employees as a whole, not just if you're in the unionized sphere. And those cases are generally litigated in state and federal court, as opposed to labor issues, which are litigated in front of the National Labor Relations Board. So when I was in my first phase of my career, I was really mainly doing just labor relations. And it's a very specific area of law. I wanted to do something more broad to kind of have a better understanding of the whole practice area. So when I went to Nixon Peabody, I was doing more of an employment litigation sphere. And then over the years have kind of always done both. And now in this part of my career have kind of reverted back to doing more of a labor relations focus, since that's kind of what I've always really enjoyed. But at the end of the day, coming at it from somebody who has had a wide breadth of experience in this field.
Thank you for sharing that overview, Steve. So you mentioned, you hinted at this a couple of times so far, which is that, you've seen things change and things, NLRB has been in the news and so on and so forth. So at a high level, what would you say are some noteworthy trends that you've seen in L&E law, both on the labor side as well as on the employment side over the past 5 years or 1 year or whatever, recent time frame of your choosing? And to what extent have they changed your practice and the advice that you give your clients?
So in the labor sphere, we're talking National Labor Relations Act, the National Labor Relations Board, what we have seen really, if I'm being frank, even going back further than you asked for, like the past 10 to 12 years, is a swinging of the pendulum back and forth between administrations. So you will have a Republican administration that will have a board and board decisions that are far more employer friendly. Then you'll have a Democratic administration that will swing the other way and be far more employee friendly. Then you go back to an employer friendly board of it. So what's difficult with labor law is you're constantly shifting the precedents. You'll have a case that was decided in the Obama era board that is then reversed in the first Trump era board, that then there's a rule in the Biden era board that vacates it, then it was then abandoned in this new board. You're really going back and forth between case law where you have to look just into the recent past to find out, has it been overruled? Is it still in effect? Even if it was overruled, was that overruled then overruled? Reversed itself. You have a very difficult situation with kind of how the president is shaking out there. In employment law, which, as I mentioned, was discrimination law, things of that nature, wage and hour, for the past many years, we saw kind of an expansion of that field into what's considered discriminatory. Now, recently with the federal law, we've seen kind of a contraction of it, and a contraction of what the federal agencies that address these types of things will consider their kind of enforcement priorities. But then the other effect of that is states such as New York, New Jersey, California, that have really effective and aggressive state enforcement agencies and city enforcement agencies, they're going to start picking up the mantle and kind of stepping into the void, so to speak, that the federal government is leaving. In employment law, it's kind of like a funnel. So the federal law is always the most narrow. and then it expands out as you go down to state law and then city law. Like, for example, New York City, the New York City human rights law is one of the most protective laws in the country when it comes to employees. And so as the federal government steps back from its role or reprioritizes some of its role, we're going to see state and city agencies that are really going to step up to and start pushing their view of the scope of these types of laws.
That's fascinating. Thank you for that overview and constantly shifting pendulum, as you mentioned. I think that's good to know for those of us even outside of the labor and employment law space. Given that those shifts of the pendulum mean that there have been multiple such matters, can you share an early career case or a particular client challenge that fundamentally shaped your philosophy around being an advocate for employers against this background that you just mentioned?
So one thing that I always tell folks, the best example is non-compete law. So non-competes are an area that, again, the pendulum has been swinging back and forth. A few years ago, we had a potential national ban of non-competes by the FTC. That was then vacated, but then the FTC just recently came out with a statement that they're going to focus on healthcare agencies, and then you have states that all implement their different laws, et cetera, et cetera. One thing that I always tell clients and how it always shapes me is you have a case. You're going to hire somebody who has a non-compete, or you're going to enforce a non-compete against somebody who you think has gone to a competitor and is violating it. The question that I always get is, well, is it valid? Isn't it an enforceable non-compete? And the answer that I always give is, it could be, it could not be. But you know who's going to tell us? The judge, after we go in front of them and spend a significant amount of attorney's fees and time putting in the briefs and the evidence and all of that. And so what I always take from that kind of viewpoint is, the law is just as important as the way you tell your story and who you're telling it to. So in labor and employment, you're dealing with a lot of different types of people that you're telling your story to. So in litigation, you could be telling it to a judge. In an investigation, you're telling it to an investigator who may not be a legally trained judge or lawyer, but they're an investigator who knows what they're looking for and has specific areas that they want to address. How you're going to present a set of facts is much different in front of the judge than in front of the investigator. So in front of a judge, you're going to want to really make sure that you have your legal precedent tightened up and your facts tightened up and tie it into all of that. An investigator may not be as concerned with the law because they have a different standard that they're looking at, and they may want to be putting in front of them more, heavily on your facts and how you're presenting that to them to try to convince them that this investigation is, not really where they think it's going to go, and it's not worth the resources that they're putting into it because there's just no there, as you like to say.
No, that's fascinating. I like something that you said there very much, which is that you said, the story, it depends on who you're telling the story to and what story you're telling them, and also how you're presenting it to the different archetypes that you provided in terms of the judge and the investigator. Maybe let's take that down a slightly different angle and switch gears a little bit to the use of technology and innovation in the work that you do, right? So if we ask the question of how is it that you use technology or other innovative strategies, AI, all of those things, when telling these stories to these various stakeholders? What is your current approach, and how do you see the use of technology in that storytelling for that individual or that stakeholder?
Sure. And so, like, I'm sure you've heard this from a number of folks on your podcast, is the legal field, I think, is more of a slow adopter of AI than other fields. I know there's a lot of concerns, especially in the court scenario, of the use of AI and what have you. And so the way that I view technology and AI in the practice is, it's going to help me present a more clear story. Then I think that's the best way that I would want to use it. And so in my view is, sometimes I want to present, timelines. It's really important for an investigator to understand timelines and how this, the case came to be. So you could create some sort of submission where you have a timeline that ties into the documents. It goes from point A to point B, and as you go through it, the investigator is able to just simply click on what you're using, and it pops up the document that they need to see. I think it's kind of rudimentary. If I'm being completely honest, I have not really put AI very strongly into my practice as of yet. We are looking at it on a firm-wide basis, and one of the main reasons is that my practice, especially in the labor field, is very negotiation driven. It's very driven to negotiating agreements, negotiating decisions, putting decisions in front of arbitrators. That is still to this day, it's a large human element to that. And how technology and AI is going to factor into that, I think is yet to be seen in this specific area. It'll be interesting to how it is, but it's still very much a bit of a, the term bargaining table is not just a term. It literally is a bargaining. There literally is a bargaining table.
That's an interesting perspective on technology and AI, especially from the viewpoint of how can it help you? Does it help you in terms of negotiation, right? I mean, obviously there are plenty of tools and offerings on the litigation side, and that's great. But it's interesting. Like it seems like when you're at that bargaining table with the counterparty, it's still a very human negotiation, and there's a lot of complexity that so far at least humans only can handle. So that's what I hear there.
Exactly, and like I think that one of the things that I can imagine that AI could eventually help assist with, or probably can at this point, one thing when it comes to negotiations is comparables. Kind of similar to buying a house. You want to see the comparables. Sometimes those comparables are not as easily accessible. Other CVAs are not publicly published documents. They're not exactly available to everybody to see. But those who want to use them to further their position want access to them. So that could possibly be an arena where that can start moving.
Absolutely. Going back for a little bit to the work that you did when you were in-house for those few years, when you were there, your role involved, working with digital health initiatives and technology contracts, and there was a certain ethos, I'm sure, in terms of how that particular organization leveraged technology. Are there any lessons or learnings or key takeaways from being in-house and seeing technology implemented in that way in an organization, in a non-law firm type organization, that you think could be applicable to law firms, whether it's yours or just attorneys at large?
So one thing that I learned from that whole experience is that to allow the technical experts to be the technical experts and to learn from them. I think lawyers and attorneys are experts in our field, but that doesn't necessarily mean we're experts in all fields. And so, when I would negotiate some of those agreements and I would work on certain vendor agreements and things like that, I wouldn't necessarily know and be the expert on the subject matter. And that's why I would go to my subject matter experts and say, they're coming back with these round of revisions. Is this going to work with you on an operational level? And, I think that's kind of where I view technology right now in the law firm sphere is the experts that are working this type of thing have to be able to explain to the law firms why this is going to help you on an operational level. And you also have to listen to that. I think that, like I said, there might be a little bit of resistance. And if I'm being honest, I think a big resistance of artificial intelligence issues right now is seeing a lot of folks, unfortunately, kind of make errors with it in a court setting, and that then becomes a public issue. And I think it then creates kind of a fear that then using this may be not the best way forward, because you have folks that may use it not the best way and then get unfortunately called out for it, when you could have folks who might be using it and are every day and are not facing those issues.
Yeah. And that's something that's come up a lot. Obviously, we see it in the news, we see it on LinkedIn, I'm sure. So it's interesting that it's almost like, are we reversing cause and effect, right? The effect of not using AI in a way that one would also leverage the talents of say an associate or a paralegal whose work needs to be checked. If that is something that is not being done for AI for whatever reason, and then that creates all the challenges that we're now seeing, is that sort of creating a bit of a chilling effect in addition to other concerns that may be more valid and grounded in the AI itself? So what I mean by that is that obviously, no work product is perfect, and AI tends to be has a lot more of a tendency to sort of create these hallucinations and all of that. But it is something that technically a review by the attorney who signs off could actually take, could actually be taking care of it, right? And so if that's one aspect of it, but are there other concerns, such as, is this technology eventually going to get good enough? And so this is again a different example of the pendulum swinging the other way, where it replaces the judgment of an attorney in some cases. And a third angle to this is there a concern that there's using it in some form is maybe not ethical or anything like that? So I know that that's a sort of wide-ranging question / comment that I made there, but what are your thoughts around, replacing judgment, competence, using your own judgment to sign off on things, and then the ethics of AI?
It's a big question.
Yeah.
So I don't think it'll ever replace the judgment of a human attorney. I just feel that, especially in the field, like in any field that an attorney is an expert in and that you work in for so long, you have so many reps of unique situations to draw on in your experience. And as I'm not an AI expert, I don't know what goes into these modules, what have you. I just struggle to believe that a module like that would be able to replicate someone coming to you with an extraordinarily unique situation, and you as an attorney being able to draw on not just your legal expertise, but also your business expertise of things you have seen work in the past, your entire knowledge of your deals and litigations and what have you, and come up with a solution for that client. That to me is a little hard to believe that may occur. The ethics of it are frankly something that I have not fully thought about. I think there obviously are some concerns with, the big thing is we're all told that if you're going to use one of these AI engines, that you can't put confidential information into it because it could be a larger issue regarding confidentiality. But what I think, to go back to kind of the original thing of people need to proof it and make sure that it's correct. I can envision in the coming years, when you file briefs with courts, you have to make certifications, word count certifications. I've certified that I ran a word count and this is under 1,500 words. I can imagine that at some point there is going to be a certification that says you have to certify to the court either I did not use AI in the preparation of this filing, or if I did use AI, I certify that I proofread and ensured that all citations or what have you are accurate and correct. So that's it's already required of attorneys under the ethics rules that they do that. But if these cases keep occurring, I can imagine that there's going to be some level of certification warranted by courts that you're.
Makes sense. Yeah. Thank you for your thoughts on that. I guess now taking a step back and looking at the field of labor employment law as a whole, looking ahead now, what do you think are the greatest trends that will fundamentally, sort of change or disrupt the practice that you're in? And it could be sort of, changing political winds and all the administrative changes that go with that. It could be the use of AI, not just in your legal practice, but also in, for example, the work that your clients do, and how does that impact the field? So what are your sort of prognostications on where the field is headed over the next few years?
So I think the next few years what we're going to see is one is states that want to step up are going to step up, and they're going to start passing more restrictive laws and more employee-friendly laws to, like I said earlier in this recording, to fill that void. You're talking AI. Like, I know that the big issue is use of AI as a resume sorting tool or as a job tracker sorting tool, and you already have cities like New York where if you use that AI, you need to subject that AI tool to an annual audit to ensure that it's not creating some sort of disparate impact or disparate treatment amongst candidates based on some unlawful characteristic. So, it's not a perfect tool, and there are states that are kind of catching up to that. And and at the end of the day, you have this annual audit in New York City that you have to do, and also the law will hold, even if you use a third party, even if you say, hey, it's not my AI recruiter, it's this, they're going to hold the employer liable for having done that. So you're going to see that we have states that are creating new requirements in their WARN laws. So WARN, for people that don't know, is a law that if you have a certain level of size of layoffs or plant closing, that you have to notify the government about it. And there's a federal WARN and a state WARN. And there are state WARN acts that are coming out that says that you also have to indicate if the layoff is due to your use of AI. And then you have AI, in the labor sphere, AI is now going to be is kind of similar to what you would imagine 100 or so years ago was mechanization. So you had mechanization that would reduce the need of workers, the number of workers, because you could do things more efficiently. So now you're talking about a scenario where it could replace workers indefinitely. And a big area where we're seeing that as an issue is the creative space. And you're seeing unions actually in the creative space fighting for language and contracts, basically limiting the use of creative employers from displacing workers by the use of AI. You're talking in writing and animation and film production and things like that. And I know there was, I just saw this the past couple of days that there's been this large uproar about like an AI actress.
Yes, I was just going to.
I haven't fully read into that, but like that's a perfect example. Is you're now having an AI actress that could potentially replace actors and actresses, and that's very. I think if you asked someone this 3 years ago if that would be the case, they wouldn't think so.
Absolutely, no, it is absolutely fascinating, Steve. So, I would love to conclude this conversation with a couple of questions asking for your thoughts and guidance. So for one group of stakeholders for whom I would like to ask your guidance is for business owners and managers who are listening. What is the most common and preventable mistake that, or I guess, workflow or process that leads them into litigation? And what is something that, it should be a number one, hey, do this or don't do this from an employer?
The number one thing is wage and hour issues. One, your employees have to be properly classified as employees or independent contractors. There's a legal test to this. You can't just say, oh, this employee is a 1099 employer, this employee is a W-2 employee. There is a legal test. And you need to make sure that your employees are being paid the hours that they work and that you have a contemporaneous timekeeping system that is recording the hours that they work. This is bar none, far and away, cannot overstate it, the field where employers most likely get tripped up is wage and hour law, and the results, the liability can be significant.
Thank you for sharing that. Moving to your advice for another group of stakeholders, which is, let's say that I'm a fresh out of law school young attorney looking to sort of explore labor and employment law. I'm faced with this societal landscape that we have today. I'm looking at all the AI, and all the technology landscape as it stands today. What sort of advice or guidance would you give to someone like that who is entering the field and entering the field of legal practice and specifically considering labor?
So my advice is, labor and employment specifically is done on a wide range of levels. There are small firms and there are large firms and mid-sized firms and everywhere that do this type of work. If that's what you want to do, I would say cast a wide net and get a job, one of your first jobs that you think is a place that you enjoy. Like, for example, I started at a 12-person law firm, and within 4 years of that was working at a 700-person law firm. At the end of the day, what I always explain to younger attorneys, and if I'm being frank, anybody who's in any stage of their career, is opportunities are everything. And you need to seize the opportunity that's in front of you. And that's really going to help you guide along your career. So, you could end up coming out of law school and working for a large firm doing labor and employment, and that's great. And if you don't have that opportunity in front of you, working at a smaller or mid-sized firm that is just as good, and you can work your way up if that's something you want to do. But I think the important thing is to not discount the opportunities.
Thank you for sharing that. Well, Steve, this has been an incredibly insightful and content-rich conversation, and I appreciate your taking the time to be with me. One final question before we sign off here. Is there a question that I should have asked you but I did not?
I think we've really covered it. You didn't ask me, how to tell if a zucchini was ripe or not.
How do you?
Which I don't
know. That's pretty funny. But it's on Google, so you have to be the expert, right? Because it's on the internet.
Listen, I hope the first thing that you're going to do is go and Google my name and see how far you have to scroll on the Google pages to see where that is at this point. I actually might do it as well.
That's pretty funny. Well, Steve, it's been a pleasure. Thank you so much for your time, and I look forward to connecting again soon. Thank you, everybody.
Thank you.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.